Okay, good morning and welcome everybody on this last day of August 31st. We're excited to be joining you. This is our second week of classes at the S.J. Quinney College of Law, so we're off and running and it's a good start. And what a better way to start our semester than talking about a really important topic, which is the Supreme Court's recent decision in Dobbs and its potential impact on same-sex marriage, contraception, and other rights. We're so glad that you can join us. My name is Elizabeth Kronk Warner. I have the privilege of being the dean at the S.J. Quinney College of Law, and my pronouns are she and hers. And as I like to do anytime that we're joining here together, I do want to acknowledge that we at the University of Utah acknowledge that this land here in the Salt Lake Valley, which is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshu, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many Indigenous peoples and their traditional homelands. We respect the sovereign relationships between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. And so we're very happy to be here on this land with you today to talk about the Supreme Court's decision in Dobbs versus Jackson Women's Health Organization. So I'm going to start today with a very brief introduction to the case, just so everybody has some context. And then I'm going to briefly introduce our speakers. And then Professor RonNell Anderson-Jones is going to start off with an introduction going much more deeper into the case and its ramifications. And then Paul Burke will be providing some color commentary and some questions and answers to tease out the nuances of the case. We will leave about 15 minutes at the end of the presentation for your questions, but you do not need to wait until the end of the presentation to ask your questions. If you look at the bottom of your screen, you should see a Q&A button. And if you just want to type your question into that space, we here on the panel can see those questions and we will ask the question when the time comes later in today's panel. So as mentioned, I just want to start the panel with a brief introduction to the case. So again, this case is Dobbs versus Jackson Women's Health Organization. It was a decision that the U.S. Supreme Court rendered on June 24th, 2022. And as I'm sure you've seen, it has been much in the news ever since. So this case involves Mississippi Gestational Age Act. Persons shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. So Jackson Women's Health Organization, which is an abortion clinic, and one of its doctors challenged this act in federal district court, alleging that it violated the U.S. Supreme Court's precedent in Roe versus Wade, and also Planned Parenthood of Southeastern Pennsylvania versus Casey. The district court granted summary judgment in favor of the respondents and permanently enjoined enforcement of the act, reasoning that the Mississippi's 15-week restriction on abortion violates the U.S. Supreme Court's previous holdings. The U.S. Circuit Court for the Fifth Circuit affirmed, and therefore this case was brought on certiorari from the Fifth Circuit. And the argument before the U.S. Supreme Court was that specifically that both Roe and Casey were wrongly decided and that therefore the act, the Mississippi Act, was constitutional because it satisfies rational basis review. The U.S. Supreme Court ultimately held that the Constitution does not confer a right to abortion. The court explained that Roe and Casey are overturned and that the authority to regulate abortion is returned to the people and their elected representatives. In other words, that states have the right to make the determination as to whether or not abortions can happen in that particular state. So as you might imagine, this overturning of 50-year plus precedent has had profound implications. And so there's going to be much to talk about today. And we have two wonderful panelists who are going to join the conversation. First is Professor RonNell Anderson-Jones, who is the Lee Teitelbaum Professor of Law here at the S.J. Quinney College of Law. And she's also a constitutional and First Amendment expert in the nation. We're also joined today by Paul Burke, who is a shareholder and general counsel at Ray, Quinney, and Nebeker. And I'm proud to say he's an alumnus of the S.J. Quinney College of Law. So with that, I'm going to turn it over to Professor Anderson-Jones, who's going to speak for about 20 minutes. And then we have some questions from Mr. Burke to discuss the ramifications of this decision. Professor Anderson-Jones.
Thanks, Elizabeth, and thanks to all of you for joining us this morning. I've been asked to sort of offer up the lay of the land on some tensions that have emerged in the aftermath of the Dobbs opinion on the question of other constitutional rights. And then I'll sort of hand the baton over to Mr. Burke for some thoughts and questions on the issue. The basic thrust of the question here and the sort of wider ramifications of the Dobbs case in the abortion space are the topic of the next webinar in this series, but we're focusing on sort of what this means for cases that aren't abortion. And the real sort of question here is, what does this holding in Dobbs, a case about the constitutional right to choose an abortion, what does it say or not say about the wider universe of rights that share a doctrinal origin with that right? In particular, I think a great deal of attention is now focused on the precedents that exist on questions of contraception and same-sex sexual intimacy and same-sex marriage, and whether the court might be poised to reconsider those rights. Those rights, just like the right of a woman to choose an abortion, are all based in the principle of substantive due process, in which the court has recognized a variety of fundamental rights that are not specifically textually enumerated in the US Constitution. The doctrine builds on the language of the 14th Amendment, the place where it specifies that we may not be deprived of liberty without due process of law. And it lays out some judicially recognized liberties that the court has said are just sort of so central to our concept of ordered liberty that they receive this heightened constitutional protection. And these included, before Dobbs, a right of privacy that encompassed a right to seek an abortion, but they also included a set of other rights. And the question is whether the reasoning in Dobbs either necessarily or potentially leads to a rejection of those protections as well. Now, partly, this conversation has been kicked into high gear because of a bold concurring opinion by Justice Clarence Thomas, who has never been a fan of this substantive due process protection of unenumerated rights. He wrote that, quote, "In future cases, we should reconsider all of this Supreme Court's substantive due process precedents." And he cited specifically 1965's Griswold versus Connecticut, which is about the right to choose to use contraception, 2003's Lawrence versus Texas, which is about the right to same-sex intimacy, and 2015's Obergefell versus Hodges, the same-sex marriage case. Because in his view, any substantive due process decision is demonstrably erroneous, he says the court has the duty to correct this error and unwind all of them. Now, Justice Thomas's opinion has been seen as sending out something of a bat signal to conservative lawyers and kind of a roadmap for pushing for those additional challenges. But Thomas, even though he's echoing here a longstanding conservative skepticism for substantive due process and unenumerated rights, he was also all alone in that statement. No other justices joined that concurrence. Justice Samuel Alito, who wrote for the majority in Dobbs, actually bent over backwards to try to say that the Dobbs opinion doesn't collapse that whole universe of rights. Here's his language. "We emphasize that our decision concerns the constitutional right to an abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion." And his opinion sort of rejects the abortion right from Roe versus Wade as, quote, egregiously wrong on the day it was decided. And really, the place that we find our trickiness here is how he and the other justices in the majority got to that conclusion. Any right not enumerated in the Constitution, they said, must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. And sort of exploring in really great detail the views on abortion as of the time of the adoption of the 14th Amendment in 1868, they concluded that this abortion right was not deeply rooted in our history, because that's what you have to be in order to be recognized as one of these rights. But of course, as of 1868, we also had no tradition of protecting choices on same-sex intimacy, interracial marriage, same-sex marriage, the use of contraception, or other rights that modern precedent now protects as fundamental. And if that's our driving analysis, and everything about the structure of this Dobbs opinion points to that being the case, then these other rights may also not survive. Justice Alito's opinion for the majority says there's an additional big way that abortion rights are different from the other substantive due process rights. That's the countervailing interest in fetal life. The opinion says that abortion destroys the life of an unborn human being and so is inherently different and a unique act, positing a uniquely critical moral question. And so for this additional reason, the majority says the Dobbs case eliminating abortion rights doesn't undermine all of those other cases. And this really shows us, I think, where the fights are going to be in the future. It's sort of a question of like, do as I say and not as I do. Whether those other rights are in peril really depends on whether we read Dobbs for what it says or whether we read it for what it does. Justice Alito works quite hard to say that abortion is different than these other privacy rights because of the existence of the fetal life component. And the opinion does articulate quite clearly the potential life and unborn human being values that can differentiate this area from others in kind of the same constitutional family tree. I don't see any explicit eagerness in the opinion itself, if we're thinking about sort of do as I say, and no explicit eagerness to unwind those other principles. Instead, something more like an effort to emphasize that this case, at least, doesn't necessarily speak to those. But on the question of the constitutional basis for the distinction, the opinion leaves a lot of question marks. And the reason that we're left with this lack of surety is that this distinction is sort of juxtaposed against that wider opinion, which, as we said, makes very, very clear that it considers history and tradition as the driving or even sole determiner of these constitutional rights. Now, it could be that there's some constitutional distinction on the basis of something like the existence of third-party harm, but that's not a distinction that we're told is rooted in history and tradition. And many rights, at least arguably, have negative consequences on third parties. Think, for example, Second Amendment rights or unenumerated right to contraception, which both involve actual or potential human life. So what's really quite confusing for a lot of scholars who are trying to predict what's next in the interplay between the sort of fetal life makes the abortion context different portion of the opinion, and the tradition and history are the governing principle portions of the opinion, is that the sort of differentiation of abortion on the grounds that there's a powerfully different third-party harm feels a little like a conflation of the rights recognition question with the later question of whether the state has a strong enough interest to infringe upon a recognized right. So at base, really, if the path to something becoming a recognized constitutional right is history and tradition as of the 14th Amendment's adoption, then abortion is out, but so are contraception and interracial marriage and same-sex marriage and a quite long list of other rights. If abortion is out, but the others are in, the opinion doesn't perfectly guide us as to why this is true as a rights recognition matter. And that's the place where we're going to see the litigation, the tensions in the litigation going forward. Importantly, if you read those other judicial opinions on those other rights and those other cases, so for example, Obergefell on gay marriage, they all suggest history is a guide, but not the only basis for finding a protected constitutional right. So those portions of those precedents, at least, seem called into question by the Dobbs opinion. The Dobbs case tells us very clearly that we answer the constitutional question in a different way now. Importantly, also, I think, throughout the history of Supreme Court jurisprudence, we've seen a number of sort of similar statements like we see here. This is only a case about X and not about Y. And everybody who works in the law knows that it's very hard to know what the court precisely means by such statements. They could mean, we will go this far and no further. Those other opinions are not implicated today and will never be implicated. This doctrine doesn't extend there. Or they could just mean, we will go this far at this moment because this is the only question squarely before us in the Dobbs case, and our role is limited to answering questions squarely before us, and we'll decide how much farther to go in future cases when those questions are squarely presented. In earlier sort of arcs of constitutional precedent before the court, we saw rights expanded in this way. So, for example, in the Lawrence case, finding that a gay man had the constitutionally protected right to engage in same-sex intimacy within his home, the court emphasized in that opinion that it was not necessarily holding anything at all about the constitutional right to same-sex marriage. And Justice Scalia sort of quite famously said, do not believe it. It would surely ultimately lead to such a holding, he said, because that's how constitutional jurisprudence works. It's about what the court does and not just about what it says. What matters is whether the principle and the logic equally apply to the next case. And it turned out that he was right. A decade or so down the line, the logic of the opinion was invoked in case law extending the principle to a right to same-sex marriage. So the dissenters in Dobbs are now warning that we will inevitably see the ratchet in the other direction. That is, if the principle and logic at work in constitutional law is now sort of entirely a question of the existence of the right in our nation's history and tradition, you can't remove, in their words, you can't remove one piece of the whole Jenga structure without the Jenga game collapsing. It just inevitably, they say, leaves vulnerable this whole other constellation of rights. Now, whether this is in fact inevitable is something that I really want to hear from Mr. Burke about, and also I think may well turn on whether there is political will, either in the wider population or the court itself, for bringing these challenges. And this policy and politics piece of it strikes me as a very important determiner of what may lie ahead. It's been suggested by some that gay marriage, for example, is simply too broadly popular a right, with polls showing both strong majorities of Democrats, but also slender majorities of Republicans now also supporting it, or been suggested that the reliance interests at stake, right, with hundreds of thousands of families having ordered their financial and legal and personal affairs around the existence of that right, such that a court that is concerned about its own counter-majoritarian institutional legitimacy wouldn't dare to unwind it. And that's a question, right, for debate. Polls also showed that majorities supported Roe, although with nothing close to the same bipartisanship. And in terms of settled reliance, Roe was, of course, significantly older than the precedent on the right to gay marriage, which is a constitutional development of just the last decade. And in fact, of course, all of the justices who overturned Roe described sort of great fealty to its status as precedent during the confirmation proceedings, which leaves open questions about what may be next. So I think we can't know with any surety how bold this court might be, and the reading of the political winds may well play a big role. I will say, just sort of one last note, that I think that there are strong reasons to think that this court's conservative majority won't have an appetite for entirely tossing out substantive due process doctrine in the wholesale way that Justice Thomas seems to urge. The doctrine is, it's at the root of many arguments with which conservatives are ideologically aligned, limited governmental authority to impose mask mandates, or parental rights to control the upbringing of their children. And through a doctrine known as incorporation, it's also the mechanism by which some rights, like the right to keep and bear arms, are found to be so fundamental that they're applicable against the states. And even Justice Thomas, who seems keen to sort of burn down the entire edifice, opted not to list, in his opinion, a number of other closely related rights, most notably the right to interracial marriage. And he has himself suggested that the court might need to find other mechanisms, perhaps the 14th Amendment's Privileges and Immunities Clause, as a tool for protecting some unenumerated rights. Now, I'm just the academic observer here. Mr. Burke works more closely in these spaces, and particularly in the LGBTQ rights space, probably has some more specific insights into the litigation strategies that led to the decision in Dobbs and what they might teach about what to expect from the court on other substantive due process issues. So maybe we can sort of hear from him some questions from Elizabeth about where we've been and kind of where we're headed, that might have predictive value or what lies ahead. But as a doctrinal principle, that's sort of the lay of the land of where the tensions exist. And I think what we might see in terms of the theories that are developed in the court and what they'll draw upon in the future.
Great. Thank you so much, Professor Anderson-Jones. And you're right, I do have many questions for Mr. Burke. But before I turn over to Mr. Burke and several questions, I had one additional question for you, which is, what are the competing visions of originalism that are at play here, and how are they contributing to these post-Dobbs tensions?
Yeah, I think this is a really important question. The Dobbs opinion is really shining a light on this question of originalism, sort of digging back and trying to imagine what the drafters of the particular constitutional provision here, the 14th Amendment, had in mind and planned to execute. And the Dobbs majority here shows a very strong preference, right? An overwhelming preference for kind of climbing inside the shoes, right? Taking the time machine back to 1868, living in that moment and imagining whether those rights were already valued and protected as of that moment, and then acknowledging them as constitutionally protected if and only if that history and tradition exists. There is this sort of competing vision of originalism that we now see from other scholars and commentators on the other side of the equation. Melissa Murray at NYU sort of most prominently is putting forth some of these positions. The sort of whole question of liberty that is enshrined in the 14th Amendment, she says, proceeds from this abolitionist ethic that was intent not only on abolishing the institution of slavery in 1868, but also on ridding the country of all the vestiges that distinguished enslavement from freedom. And among these, she says, are like those indicia of slavery that that aren't related to sort of enslavement proper, but rather to the wider sets of freedoms that were clearly at stake there. That is, a person didn't have access to civil marriage, lacked control over their children, who could be sold away from them at any time. And one obvious indicia was the sort of absence of bodily autonomy, not just in terms of labor, where there had been, total incursions on that autonomy, but also on reproductive autonomy, because one of the chief characteristics of slavery was that enslaved women were subjected to sexual predation and coercion, and their reproduction was used to perpetuate the institution of slavery. So the argument that some of these other scholars are making is that the 14th Amendment was designed and understood by all of those who ratified it to encompass all of those things and to vest those who had been formerly enslaved with the conditions of liberty. And that we have like a very keen sense from the dynamics of that time of what those elements of liberty are. So there is this, there's this competing, right? Originalist views stands in really stark contrast to the originalism that is invoked in Dobbs, and like sort of where those are going to come to the forefront is in these next stages where we think about which of those rights do or do not find a home in that originalist landscape. There is right, the sort of Melissa Murray track of scholarship argues that sort of the spirit and purpose of the 14th Amendment was to constitutionally guarantee fundamental rights for all citizens, and that the abolitionist logic that sort of undergirded the Reconstruction Amendments is part of what this set of fundamental rights shares in common, right? The right to marry, the right to parental decision-making, the right to make one's own reproductive choices, the right to bodily autonomy, and so forth. That's a history that's absent in the Dobbs opinion. And so the scholars who hold this view sort of see the concept of liberty as being read in overly constrictive ways that seemingly exclude, not only bodily autonomy and reproductive rights, but also all of those other rights that we're thinking about today, the right to marry, the fundamental right to parent, and so forth, how that originalism is going to play out in the next wave of litigation, I think is going to be an important thing to watch.
And Professor Jones, if you don't mind my jumping in, one of the striking things about Dobbs is what's not in it. You've highlighted, Justice Thomas's interest in the Privileges and Immunity Clause. You also have the Equal Protection Doctrine in the 14th Amendment. And so one of the things that could have happened in Dobbs is Dobbs could have revisited the reasoning for recognizing a woman's right to bodily autonomy and integrity. And it could have just changed the rationale. Roe could have been seen as wrong in grounding that right in substantive due process, and you could have seen Justice Thomas, who has been consistent throughout his career in favoring and wanting to revitalize the Privileges and Immunities Clause. You could have seen the court shift the rationale for that right from substantive due process to equal protection and or the Privileges and Immunity Clause. But that clearly didn't happen. So the one thing that is consistent, and I know we'll talk about this more, the one thing that was consistent and the one clear principle is the court's hostility towards the right of abortion that it's now abrogated. And that's been clear throughout the year, not just in the Dobbs case, but in its handling of the shadow docket. And so it's clear that 5 votes is what it takes to make things happen at the Supreme Court. And there were 5 votes this year to abrogate Roe v. Wade and to reverse Roe v. Wade, to be precise.
Yeah, it's fascinating. And Mr. Burke, that's a great segue because I have a lot of questions for you. My first question is kind of looking back, what can we learn from the path that the abortion case took in the court and the way it might signal what litigants in the court hope to do in these other areas like same-sex marriage, contraception, et cetera?
Okay, well, thank you. And before I tackle that question, let me thank you for your generous introduction at the beginning and for the invitation to be here today. And I should make clear that I speak only for myself today. I'm not speaking for my law firm. I'm not speaking formally on behalf of Equality Utah today, on whose board I serve. Nor am I, speaking for my alma mater here, the University of Utah College of Law, of which I am proud to be a graduate. So any opinions, and especially the errors I might make today, are mine alone. Now, turning to your question, I think that we can look towards the future based on the path of what happened with Dobbs and on a broader sense in the campaign against the right to abortion. I don't think the right to abortion, really ended in this country with the Dobbs decision. For all practical purposes, it ended several months earlier when, on the shadow docket, the United States Supreme Court allowed a Texas heartbeat law to take effect. And that happened on the shadow docket. And what I mean by that, that's a relatively new term that's been coined to describe cases that come to the Supreme Court, not on the regular docket through the granting of certiorari, but rather on interlocutory or some other form of intermediate appeal. And the Texas heartbeat law was scheduled to take effect. It was enjoined at the district court level, I think, but then the Fifth Circuit Court of Appeals allowed it to take effect. And so an appeal of that reached the Supreme Court, not on the full merits, but just on the question of whether the law would be allowed to take effect or not. And the Supreme Court allowed that law to take effect, even though it very clearly came into conflict with standing law from Roe v. Wade and from Casey. And that was so clear that even Chief Justice Roberts voted to, at least for that time, to enjoin the law. And we know that Justice Roberts is no fan of abortion generally, He concurred here in Dobbs, even though he wouldn't have gone as far as some of his colleagues. So I think that background with the heartbeat law out of Texas and the use of the shadow docket gives rise to concern about what might happen now in the future in attacks potentially on the right to marriage equality, same-sex marriage, and the Obergefell decision. I don't think it's beyond the realm of possibility to expect that conservative states legislature might, just as Texas passed a heartbeat law, might pass a law that targets some aspect of the Obergefell decision. Marriage, of course, is composed of a large bundle of rights, and you could imagine a conservative legislature taking one of those rights and targeting it. And then you could see the same pathway to the Supreme Court, where a district court may or may not enjoin such a law that might be in conflict with the equal guarantees of Obergefell. And then a circuit court, and the Fifth Circuit again would be a prime suspect. Perhaps the Fifth Circuit would allow such a law to take effect. And then, just like the Texas heartbeat law, you could have a challenge to Obergefell reach the U.S. Supreme Court through the shadow docket and not a full decision. So I can imagine that the legal strategies that were used to campaign against Roe and against Casey may be redeployed in an effort to try to reverse Obergefell.
Great, really interesting, and it's interesting how that shadow docket comes into play. Maybe you could, I know because we've gotten some questions about kind of the terminology that we're using. Maybe you could just briefly explain what the shadow docket is for our non-law folks who are on the call.
Is that a question for me or for Professor Jones?
Whoever wants to field it.
Well, I tried to describe it a little bit a moment ago, which is to say that it's not the full merits set of cases that the Supreme Court handles after consideration by a district court and a circuit court of appeal. Instead, the shadow docket largely consists of petitions that reach the court and motions seeking to stay or enjoin laws before the full decision on the merits is made by a district or circuit court of appeal. So, the shadow docket has always been part of the Supreme Court's work, but in recent years, the shadow docket has become much more prominent and has been used in an array of areas to create substantive change in the law. And so it's not just with abortion, but it's also occurred with respect to elections and several other areas.
Yeah, the term was most famously coined by a scholar at the University of Texas named Steve Vladeck, who started collecting data to sort of demonstrate the shift, the sort of number of unauthored short order opinions from the court that have substantive outcomes in terms of doctrinal movement. And he's tracked sort of two simultaneous trends, a shrinking substantive docket of the court in which we have full briefing and oral argument and an opinion on the merits that gives a sort of full articulation of the reasoning. That docket is shrinking, while at the same time, this docket that he labels the shadow docket, these sort of emergency decisions that come to the Supreme Court that are decided without the benefit of oral argument and without opinions from the court that follow the traditional sort of delivery of the facts, explication of the relevant doctrine, sort of citable precedent going forward. That's going up while the number of cases that the court is taking are going down. And Vladeck also argues, as Mr. Burke just described, that increasingly it's becoming a tool for pretty significant shifts in doctrinal movement. Another space where this is happening is the free exercise clause, religion clause jurisprudence. During the COVID era, a number of pretty key cases about the so-called most favored nation status of free exercise claimants came before the court, and a lot of folks who work in that space sort of think that the doctrine has radically changed, but we don't have a solid opinion on the merits to point to, because it happened in this through this other mechanism that is different from a petition for writ of certiorari.
One of the other important consequences of doctrinal change through the shadow docket is that it makes the jobs of district court judges and circuit court of appeals judges much more difficult. Consider the time period between when the Supreme Court allowed the Texas heartbeat law to take effect until Dobbs. In that window, theoretically, Roe v. Wade and Casey were still the law of the land, but through the shadow docket, the Supreme Court had given a very clear signal that those cases were not favored. And so the work in the interim of district courts and circuit courts of appeal is much more difficult when the Supreme Court isn't issuing full decisions with reasoning and walking through the precedential analysis of whether or not to overturn precedent. Instead, through short decisions in the shadow docket that sometimes are just paragraphs and sometimes are a single paragraph, they're signaling to circuit courts and district courts, and that has given district courts and circuit courts more leeway to maybe reach preferred outcomes by judges. That would be one way to characterize it, or the other way to characterize it would be to say it's making it much tougher for lower court judges to follow the law when the Supreme Court is sending mixed signals.
This is just absolutely fascinating. We did get one other request for just a brief definition. Professor Anderson-Jones, we were talking about originalism, and somebody asked for just a brief definition of what originalism is. Maybe you could briefly define that, and then I have several more questions for Mr. Burke.
Yeah, sure. At base, originalism is an approach to constitutional interpretation that suggests that the best way to decide the contours of constitutional meaning is to explore the words and intent of the founders who drafted the particular language. We've spoken for a long time in constitutional jurisprudence about originalism as sort of climbing inside the shoes of the folks who wrote the Constitution, the framers, right? It's like a 1780s and 1790s inquiry. Here, the originalism isn't quite so original. It's a little bit further down the line, and that's because the relevant constitutional text at issue is the 14th Amendment, which came as a package set of post-Civil War amendments. And so it's 1868 that we're thinking about, but it's still the same. It's the same approach, the same toolbox, which is the justices saying, we're not at liberty to think about what we think lives within the sort of growing meaning of the Constitution, but instead are moored to what the folks who authored this particular constitutional text thought and would have recognized at the time, what the meaning of the phrase and the sets of rights that were acknowledged at the time might be.
One of the ironies of the use of originalism in the Dobbs decision is that originalism is often portrayed, especially publicly, as a contrast to the concept of a living constitution, for example, an evolving constitution. And the irony with Dobbs, of course, is that we do have a living constitution. It has changed in the last decade. In 2015, there was a right to abortion. There was a right for women to bodily integrity that no longer exists today. And the principal reason that the living constitution has changed is because Ruth Bader Ginsburg is dead. And the composition of the court has changed. And we can talk about all of the reasons why the composition of the court has changed. But I at least find some measure of irony that originalism is touted in moving the Constitution and reversing Roe v. Wade. And we find that the Constitution is indeed a living creature and has changed dramatically and really a constitutional earthquake that is the Dobbs case.
Great. So speaking of that, kind of given this earthquake now and these changes to the court, Mr. Burke, looking ahead, what might the role of substantive due process, the substantive due process doctrine or the privileges and immunities doctrine in the Obergefell area, what has that been your focus, or how do you think that'll come into focus?
Well, as both Professor Jones and I have talked about before, there's a real opportunity for the Supreme Court, if it wanted to revive the Privilege and Immunities Clause, to revisit some of the cases on substantive due process and maybe reroute the rights that have been recognized in the 14th Amendment's Equal Protection Clause or the Privileges and Immunities Clause. I have to confess I'm a little bit of a cynic that that's going to happen. It clearly didn't happen in Dobbs. And I think the clear principle in Dobbs was that there was hostility from, a majority of the members of the court towards, the right of abortion. Justice Kavanaugh received a fair amount of attention for writing in his concurrence that in Dobbs that the Constitution is, in his words, scrupulously neutral when it comes to abortion. He said that the Constitution neither, permits or outlaws abortion. But the Supreme Court then said what was happening was that the court was returning to the people and the people's representatives the right to make laws in this area. But that, of course, is not consistent with the whole idea of rights, and especially on unenumerated rights, allowing people to vote on other people's rights. Allowing legislatures to pass laws about other people's rights is just inconsistent with that notion. So I think that the idea that the court is scrupulously neutral and then allowing legislatures and people to vote on other people's bodily integrity and to make laws to that effect is a little disingenuous.
One more question, Mr. Burke. So on the political front, since it's kind of a good transition, what support do you see in the public for the retention of these rights? And how does the court's concern for its own institutional reputation potentially play in this? I mean, certainly the court's, I believe I saw an article that said that the court's public opinion is at some of the lowest it's ever been. How do you think these issues will come into play?
Well, let me say first what the court said in Dobbs, which is the court, wishes to make its decisions, irrespective of public opinion, and the several of the justices have made it clear, both in this decision and in others, that the Supreme Court doesn't, put its finger into the air and make constitutional decisions based on public opinion. Now, having said that, the court has chosen in the realm of abortion to take on, to take a position that is contrary to the wishes of a strong majority of Americans. And I think that is the reason why, in the wake of the Dobbs decision, that public opinion and public approval of the Supreme Court has dropped dramatically. I think the court would put its public standing at even greater risk if it were to take on the right of same-sex marriage and marriage equality, were it to flirt with overturning Obergefell, given that marriage equality, as was noted before, is now supported by more than 70% of Americans, and even a majority, albeit a slim majority, of Republicans. All of this, I think, highlights that the Supreme Court is in a unique moment in its history. Seldom has the Supreme Court put itself up against popular majorities in the way it has done in Dobbs, and maybe flirting with doing so in the future. There have been a few times in the life of the court where it has created controversy and been against the popular will, and it has not gone well for the Supreme Court in those instances. One, of course, the most famous is the Dred Scott decision, that was one of the causes of our Civil War. We have 9 justices of the Supreme Court today because the Supreme Court, backed off from conflict with the Roosevelt administration and the New Deal at a time in the 1930s, when the court for a period of time was striking down laws and regulations that Congress was passing at the behest of the Roosevelt administration. And we had conflict there that the Supreme Court eventually had to back away from. The switch in time really did save 9 at that moment. Now, moving to today, we have a time where the legitimacy of the Supreme Court can really be questioned in a way that is maybe unprecedented in American history. The structure of our Constitution surmised that the composition of the U.S. Supreme Court would follow the popular will as expressed through presidential elections and to some extent senatorial elections too, because of the advice and consent process. But today, if you look at the justices who overturned Roe in the Dobbs decision, you have several who were appointed due to quirks by presidents who didn't win a majority of the popular vote, who came to the presidency solely because of the Electoral College. And those are the appointees of President Bush, who only came to the presidency in the year 2000 because of the Electoral College. And the same is true for President Trump and his 3 appointees. So it really is extraordinary in American history that the Democratic Party, for example, has won the popular vote in 7 of the last 8 elections, yet can count only 3 appointees on the United States Supreme Court today. And I think that sets up a real question for our country moving forward about the standing and legitimacy of the Supreme Court in its decision, and particularly when it decides to make dramatic changes in constitutional law against the clear expressions and clear will of the American people. And I think the Supreme Court does that at its peril.
Wow, so interesting. I think we could talk about that all day, but I do want to leave time for questions and answers. And just by way of reminder to those of you who are watching, if you do have a question for our amazing panelists, the Q&A button's at the bottom of the screen, and feel free to submit a question. And we have several submitted already. So our first question says, if I recall correctly, Justice Thomas did not list Loving versus Virginia as one of those cases that should be revisited. Does Loving rest on the same substantive due process foundation as Roe?
Yep. The short answer is that yes. Loving recognizes among the fundamental rights that are contained within substantive due process is a fundamental right to marry. It is the precedent that ultimately gave rise to Obergefell, the sort of core substantive due process right at issue in both cases is a recognition that central to ordered liberty, central to one's protected constitutional rights is a right to choose to marry the person of their own choosing. Loving versus Virginia, for those who aren't familiar with it, is a case involving interracial marriage, striking as unconstitutional a ban on interracial marriage. And the court drew upon this substantive due process principle. The questioner is right that Justice Thomas doesn't list that in his sort of string cite of substantive due process cases that should go away. It's notably absent. The reason for that, there are a lot of speculation for the reason for that. One speculation is that he was just listing examples and he just chose a set of recent examples and it didn't make the list. And he himself says, he uses the word all in the sentence right before it. All substantive due process cases should be, that doctrine should be, all of it should be unwound. So it may be that these are just illustrative examples, and he does mean that this should be included. Notably, Justice Thomas is himself in an interracial marriage, and so there might be some sensitivities that are at stake in that place. Although I think, to be fair, I think his argument is that he would unwind substantive due process protection and then seek protection elsewhere for some of these rights that are seen as fundamental, right? There would just be a shifting of the doctrinal home, but which of those would survive and which wouldn't is unclear to us. It may also be that he thinks that loving is too rooted, that there's some period beyond which the precedent is too deeply ingrained, and therefore it is a part of our history and tradition, or it is there's so much reliance interest on it that it must remain. But that hasn't traditionally been Justice Thomas's approach. It may be the approach of others, and perhaps he's foreseeing that.
And it's only fair to note there that Loving and Roe are roughly the same age. That Roe is only a couple of years after Loving. I'll also note, since Loving has been raised, it's worth noting that Congress has started to take some action with respect to Loving and Obergefell. The House of Representatives has passed a law that would protect interracial marriage, as well as the recognition of same-sex marriage by the federal government. So you see already a congressional response to the Dobbs decision, and a recognition that each of our branches of government have a role to play in terms of constitutional interpretation.
That actually leads really nicely into another question that we received, which is, if Congress passes a law protecting a woman's right to abortion, would that affect the other privacy rights by putting the court on notice?
That's an interesting question. What it would do is set off a second chain of constitutional challenges that reside in a different space. So the set of constitutional challenges that we have before us right now are our substantive due process challenges. That's the sort of family tree that we've been discussing here. Presumably, the next steps to challenges, if Congress said, as a matter of legislation, we will provide for federal protection in this space. Then it shifts the litigation strategy to challengers in that space to Congress's authority to enact such a piece of legislation. And there'll be congressional authority challenges, and presumably the outcome of those challenges to the use of congressional authority will also dictate Congress's ability to legislate more broadly in some of these other spaces. I think we may well there's some chance that the confluence of political and jurisprudential developments here will mean that both sets of challenges and pushbacks will be happening simultaneously.
I think we could also find out whether the that could trigger a fight about whether the Constitution actually prohibits abortion across the board, notwithstanding what Justice Kavanaugh wrote in his concurrence. This is the idea of personhood. And there are conservatives who would like the Supreme Court to recognize the right of a fetus to be recognized as a person, and to therefore have a right to life, which would then mean that it would be unconstitutional to allow abortion. So it's possible that Dobbs may just be the beginning of a larger doctrinal evaluation of abortion in the context of the Constitution. So watch for personhood sort of arguments, because the Dobbs decision has several places where the personhood argument is sort of teed up for future litigation.
It's certainly going to be an interesting interaction between Congress and the court moving forward. Our next question says, is the court's history and tradition test applied as a threshold requirement before we get to the traditional constitutional balancing test, i.e. strict scrutiny, immediate scrutiny, rational basis review? Or does history and tradition replace those tests?
That's a really good question. And I think part of the issue here is that the abortion jurisprudence has always muddled this question. And Dobbs, rather than clarifying, I think further muddles this question. The Dobbs opinion suggests that it's a rights recognition question. That is, what we're doing is at the outset, we're trying to make a determination about what rights in this constellation of rights are protected under substantive due process and which ones aren't. And the court says the framework that we're going to use for making that determination is this originalist inquiry that focuses on being deeply rooted in history and tradition. But then it layers onto that this notion of abortion being different, not just in degree, but in kind, from a wide variety of other rights that don't have a history and tradition, because abortion has this harm component, this fetal life component that the others don't have. That fetal life harm component feels like an application of that next stage that the questioner is asking about. It feels like not does the right exist, but sort of how powerful of a countervailing governmental interest is at stake to overcome that right. But the Dobbs opinion melds them. It morphs them all into this first inquiry about the bare existence of the right at all. And I think that's going to be a place where in the sort of additional questioning that we see down the line about the boundaries of the Dobbs opinion as a model for substantive due process, how much that comes into play. It may throw into disarray the sort of wider structure of the inquiry in ways that the questioner's relying on. Yeah, it's a good question. One that we don't have a satisfying answer for. Yeah.
I know, and it's fascinating. I'm just thinking constitutional law, the class just got a lot more complicated.
Yeah, I should get paid to do a new prep because that's what con law just is. It's a new prep.
Your dean should totally.
Somebody should take that up with my dean. Yep.
Okay, I think this will probably be the last question that we have time for. And it says, it seems to me that the Equal Protection Clause would provide a basis for some of the threatened rights. Am I missing something? For example, the right to marriage is well established, and now it is a matter of equal protection to have access to that right.
I think that point's really well taken. And I actually think the Equal Protection Clause is the more natural sort of venue for rooting these unenumerated rights. But at the end of the day, the principle that will govern all of this is what Justice William Brennan famously said at the Supreme Court, which is you can do anything with 5 votes around here. And in the coming years, we will find out if there are 5 votes on the Supreme Court to reroute some of these rights in the Equal Protection Clause. We may also find out if there are 5 votes on the Supreme Court to revoke additional rights that have been recognized by the court in the last 100 years.
All right, fantastic. So I apologize that we're out of time. I see that there are several other questions, but do not despair. This is just the first of 3 conversations about Dobbs. So we will continue this dialogue tomorrow at noon, September 1st, with the College of Law and College of Nursing's panel on what the Dobbs decision means for medical professionals. So what are medical professionals supposed to do when making decisions in light of the new holding from the court? And then we'll also continue this conversation about the aftermath of Dobbs as part of our annual Fordham debate. So this will be the topic for our Fordham debate in September. So stay tuned for that information, and we hope you can join us. So with that, I just want to thank our 2 panelists. Again, amazing conversation. Fascinating topic. We really appreciate your great in-depth analysis, and thank you so much for taking time with us today, this last day of August, and starting our semester off on the right foot. And to our attendees, thank you so much. We hope you can join us tomorrow for the second panel on Dobbs, and we hope you have a great day. Thank you.